thank you for joining us today. Lovely to see such a healthy attendance list and lots of familiar names on there and lots of new names. That's wonderful. What we're going to be looking at today is the headlines of the Procurement Act that's coming up. And then we're also just going to talk about how we're going to deal with training on this topic going forwards, because there's a lot to get through and a lot to think about. So what we're going to be looking at today, just in terms of an agenda, is we're going to have a quick look at what the procurement key headlines are, why it's important, some of the key themes. So for those of you who just want an idea of what's going on, that'll give you the idea and a general overview. We'll also be looking at the upcoming webinars, which will go then to kind of drill down into more detail into the various areas that have changed under the Act. And I'll just explain a bit about why we've broken it up that way. What we can't cover today, just because of the sheer size of the legislation, and also because it certainly wouldn't fit into half an hour, maybe not even 2 days, is a detailed analysis of the legislative provisions. So we're not going to look at the details of things. We're going to try and give you an overview of what's changing, so you can see what's coming up, and it gives you a good idea of where things might be different in the future when you're looking forward to contracting, what might be different. We're also going to have a look at a few of the detailed provisions, but only the headlines. What we're not going to do is also look at the light touch regime, which similarly to the current regiment, there's also that in the new Act. And we're also not going to go into the defence, utilities or concessions part of the Act, because as you'll come on to see in a minute, they've all been consolidated now. So what's it all about? Those of you on the call probably already got a bit of an interest in procurement or know a bit about it. Generally, public procurement has been subject to a regime for a long time to make sure that everything is done fairly, that everything is done transparently, that everyone gets a fair crack at the whip effectively, and that there's transparency in public spending. There have been various regimes over the years, but the EU regime and the consolidation of the EU regime and the various rules under that effectively where we are and have been for quite some time. Post-Brexit, and then post-COVID probably is also a big driver. There's been a change within the government and a will to have a new regime, our own regime, and one that's for the UK only. So the procurement bill has been, well, it's felt like a very long time coming. It's received royal assent 26th October last year. It's going to pass into the law, it passed into law as Procurement Act 2023, and expected to come into force in October 2024. It's not a definite date. We have been promised a go-live period of 6 months, so hopefully around April of this year we'll know whether that's a definite date. I think the reason it's still up in the air is there's still a lot to do. So there is still a lot of things going on in the background, and there's still some secondary legislation that needs to come in to put a lot of meat on the bones of the Procurement Act, because a lot of it is left to the lawmakers to add to, which James will mention in a moment. And I think it's fair to say that it's a really quite significant shake-up of the current system. When it was being talked about in policy terms, the idea was to try and make things quicker, more effective, to try and free up contracting parties to get to the end point quicker, and also to try and get more small and medium-sized enterprises into public contracting, and to try and open the doors a bit and open up the competition for these contracts. The actual Act itself has got some kind of aims stated in it. So it talks about delivering value for money, maximising public benefit, sharing information so that everybody knows where the contracting authorities are up to allow suppliers to understand the authorities' procurement procedures and policies and decisions. And there's also a clear driver through all this to want to be seen to be acting with integrity and to be wanting to seen to be transparent. And it's not that wasn't always a statement from the beginnings of the the review of the position, but I think it's fair to say that the COVID issues and all the challenges over the procurement and that have been a key driver in the bill and then the Act to try and make sure that there's more transparency over that, and whether that's going to be helpful or not, I think we're just going to have to wait and see. That's a clear driver through the provision. Another thing to probably say is that obviously we've lifted this out of the EU regime, and if you look through the Act, it's quite obvious that sometimes words have been used just to use a different word from the EU regime. So we've got some things that we're not entirely sure what they're going to mean yet, and there's going to be a period, I think, where we're all trying to figure that out and some of which we'll have to probably wait and see what the courts say on some things I expect, as usual with any new legislation. But we've got things like, we no longer have the principle of equal treatment as such, but we have an obligation to treat parties the same unless it's justified. And we've got, instead of the most economically advantageous tender being the one that has to be awarded, now we've got the most advantageous tender. So, so there's quite a lot of stuff that's up in the air, and we're not entirely sure what it's going to mean or where it's going to get us to. But what we can see is that there's quite a few various areas that have changed quite a bit. We can see that the detailed secondary legislation is going to build on that as well. And in effect, we've got a very large act that makes tweaks to a lot of the existing regime. Sometimes there are some significant additions. There are things that have been taken away. But overall, there's a really large chunk of changes that are quite difficult to look at in overview. And so, you kind of have to look at each kind of section of where it's changed to try and get a flavour of what is changing and why. So what we're going to do today to try and give you an idea of that, but without overloading you or being so detailed it's meaningless, is to try and go through some of the key areas. These are by no means the only changes. There are lots of tweaks through this, but these are the kind of key areas that you can look to and say, well, there's a clear change there. So what are we going to look at? We're going to have a look at transparency. There's been a lot of movement on that, and James will come on to talk about a lot of the measures that have been put in place that are, that they're certainly billed as there to drive transparency. Contract award and performance management, and performance management in particular is a big shift in this regime, and that's going to be interesting to see how it plays out. We've got exclusion and debarment provisions, which there have always been these provisions to some extent, but there's a new regime on these on those provisions. There's a change in relation to the automatic suspension, and then there's quite a big change in relation to procedures. So we're going to go through each of those areas, and then at the end we'll just talk about what's coming up and how you can get some more detail on these things. So with that, I will hand over to James to talk about transparency.
Thanks. So as Lynsey said, there's a big focus on transparency in the Procurement Act, and it was one of the government's key objectives when pushing through the act, was to improve transparency in public procurements in the UK. And when you look at the policy papers that went out while the act was passing through Parliament, they discussed how the idea was to make sure that people can understand the UK public sector, who wants to buy what and how much they're spending and with whom. And one of the ways that the Act does that is by introducing several new publishing requirements and notices that have to be published throughout the procurement's life cycle. And that's from the planning stage right the way through to contract expiry. And they include things like pipeline notices, so where a public body has plans to procure more than £100 million worth of works, goods and services. They must publish information on potential future procurements where they expect to conduct in any given year, where they're over £2 million. So that sort of future-looking notice provision is a new sort of thing. There's also publishing requirements for key performance indicators, which I'll come on to speak about in a bit more detail later. And then again, termination notice provisions, which effectively mean that within 30 days of any contract expiring, either by natural expiry or otherwise, there needs to be a notice published. So they're just a few examples. There's many more, and we'll come on to speak about them in more detail in future seminars, but it's just an example of the higher burden of notice provisions on public authorities. And we understand that authorities are understandably concerned about the increased burden of those notice provisions, and it will mean making sure authorities have the appropriate people who can manage those notices, the giving of those notices. There is a central central notification portal that's going to be set up, which will provide greater visibility of what's going on in the market. From a supply perspective, it gives the opportunity to look at what's going on in the market, what your competitors have done, And there's also some interesting opportunities where there's, for example, mandatory notices relevant to direct awards or contract modifications. We anticipate there'll be more opportunities for challenges and potential litigation leading on from that. But as Lynsey said, there's an element of this which is a little bit up in the air and waiting to see what happens when the Act comes in. But the key takeaway for suppliers is it's going to be important to keep track of all those notices and act accordingly on their publication. In terms of how those notices will look, the draft transparency regulations set out the government's proposals for the detailed content of the notices, and they did a consultation which ended in August 2023. But we're currently awaiting the government's response to these. So, as Lynsey said, there's an element of the secondary legislation having to come in before we can really get a full picture of what these notices are going to look like. But they will hopefully make things more transparent. But the drawback of that is the amount of work that goes into putting these notices up and responding and acting accordingly.
Sorry, just to interrupt you slightly there, James, before you move on to the next slide, I just wanted to mention that if anyone did have any questions, we've got a chat box in the bottom right-hand side, so feel free to pop questions in there. We'll get to those at the end. So I didn't think there was any point waiting until you finish, James, to put that up in case there's more questions as they go. All right, I'll let you get on.
Yeah, thanks. So the next one is contract award and performance. So again, this is one of the key changes in the Procurement Act and in the way that performance is managed once contracts have been awarded. So whilst the current regime provides that prior poor performance should be considered where there is a breach which resulted in serious repercussions such as termination, the new Act is intended to put more focus on improving performance and publishing information around the performance of contracts. As mentioned previously, the new rules around publishing KPIs will be an important change to the way contract performance is managed, and essentially where contracts have an estimated value of over £5 million, contracting authorities must set out at least 3 KPIs. There are certain exemptions to that, where, for example, the authority considers that suppliers' performance could not be appropriately be assessed by the KPIs, but they are relatively limited. And then once those KPIs have been published, at least every 12 months, the contracting authority must publish an assessment of those key performance indicators. And that'll be a big change for both authorities and suppliers. From the authority's perspective, there's an element of the work going into formulating the KPIs and monitoring the KPIs, and from a supplier's perspective, having your effectively an analysis of your performance of the contract published and viewable by competitors. It's a new thing that we're going to have to get used to. In addition, the contracting authorities will have to share information about breaches of contract or poor performance, including the ones that result in termination, payment of damages, or settlement agreements, for example. And they have to publish those within 30 days of the poor performance. So that relates back to the notice provisions, and it is quite interlinked, this performance management and notice provisions. In terms of the KPIs, as I said, then it's a new thing, and it's to be seen how that really works in practice. But we envisage that parties are not going to be wanting to sign up to KPIs that they cannot realistically be met. And so there is a risk that the KPIs become overly broad and standardized and not really appropriate for the contract to be workable. The Act itself doesn't provide much detail on what the KPIs are supposed to cover, and we suspect that there'll be some guidance in the 6 months prior to the Act coming into force around what the KPIs need to look like. But at the moment, what we know for certain is that setting and monitoring KPIs is likely to mean a lot of work for both authorities and suppliers in terms of making sure that you're hitting those KPIs, and formulating the KPIs as well is also a difficult task. In terms of what the KPIs will, and working to KPIs will look like in practice, public bodies will need to ensure they've got adequate resources to fulfil the increased obligations, and that includes having staff that are suitably trained in terms of data protection and informed on what can be published and what can't be published to the into the market regarding sensitive information. And it might mean redacting certain information and things like that. Obviously, from a supplier perspective, having information publicly available and open to scrutiny from competitors it's quite daunting, and suppliers are likely to be concerned about the potential release of commercially sensitive information. So they'll want to make sure that authorities have appropriate systems and checks and balances in place to make sure that only the appropriate data is going out. The central digital platform hopefully will make things more streamlined, but again, we'll have to wait and see how that works in practice. And obviously, we're now not very far away from the October target, so hopefully we can get some good guidance on that. But at the minute, there's not an awful lot of information on how that will work in practice. So yeah, the performance management is going to be a really interesting change to the way things work, because suppliers are definitely not going to want to fall foul of those KPIs, and the exclusion and debarment section that I'm going to come on to in a second really highlights why people don't want to fall foul of those key performance metrics. So just moving on to the exclusion and debarment section, and this sort of follows on the theme of transparency, performance, and then what happens when performance doesn't meet the standards. And the debarment and exclusion regime changes are some of the key changes, I think, in the Procurement Act, and some of the ones, especially the debarment regime, it's one that's caught a lot of people's eyes in terms of what that really means in practice. The key driver to these changes is the intention to take tougher action on underperforming suppliers and ensuring consistency across the different public sector areas, and also to try to deduplicate the screening of suppliers, really. The new debarment list is intended to be a central public register of suppliers that are barred from being awarded contracts, and there's a high likelihood that's going to be an area where there's some litigation between parties, or some disputes between parties about being added to the list. It sits alongside the exclusion framework and will be centrally managed by a Minister of the Crown. And it's not clear at this stage whether that list is going to be available to the public. While that was a key bone of contention in the consultation process for the reforms, it's not really been clarified in the explanatory notes of the Act, but it will be visible as part of the central notification platform to all public authorities. Essentially, if you're added to the list, you're debarred from applying for public contracts for a specified period. And that you can apply for the removal from the list if there's been a material change in circumstances, and there are ways that you can appeal being added to the list. And yeah, it's quite a daunting prospect to be debarred from procurement, and for many suppliers that could be a potentially insolvency scenario if you cannot continue to act in public procurement. But the idea is the idea is to stop bad performers from acting in the market. The aim the exclusions framework is largely similar. It has been expanded slightly, but it is largely familiar, at least, to the previous regime, and that, as I said, sits alongside the debarment regime, and together they present some real risks to suppliers looking to bid in the UK public sectors. For authorities, they'll need to keep in mind the potential impact of the performance criteria that's set out in the KPIs. So if you're setting KPIs which are unrealistic and then that has knock-on consequences, that the potential is that bidders just aren't going to want to bid on contracts because they don't want to risk falling foul of the exclusion and debarment regimes. Notwithstanding the fact that they don't want the poor performance public, the fact that they could potentially be debarred from future procurements makes appetite to bid more questionable. So the suppliers need to consider all those elements, and the other thing that suppliers will need to consider is when you're part of a larger group, you'll need to conduct due diligence on the corporate structure to ensure that the parent, subsidiaries, and any connected persons don't fall foul of any of the mandatory or discretionary grounds under the Act. There's an element of during the next few months to make sure, looking through the supply chain, looking through the corporate structures, that you're in a fit state for when the Act does come in. So I think that's it on exclusion and debarment.
Okay, well, I'm just going to have a little talk through what's changed on the procedures, but just before I move on to that, I just wanted to mention that on the automatic suspension. So many of you'll know that if you challenge a procurement after you've been given your debrief letter, you've got, a 30-day period to challenge that. There's been a change so that the automatic suspension that stops the award of the contract only now comes in if you issue proceedings effectively within 8 working days of the contract award notice. So it's not the debrief letter anymore. So just to highlight, there's another change there. Again, one of many, but one that's worth probably just mentioning as one that's quite a big deal, and the one that we expect to change people's behaviour. So it means that we might get more claims issued within that period to try and stop the award of the contract notice, even though in practice how much of a difference it will make, because it's relatively easy for a contracting authority to get that lifted, because obviously there's lots of public interest in contracts being awarded and procurement's not being derailed. So that's just another one that sits in there. But in terms of procedures, there's quite a big shift on this. So we did have, I think it was up to 7 types of procedures under the existing regime. Now we're only going to have technically 2, well, main ones, and then also frameworks, dynamic markets are still staying. So we're going to keep an open process, which is a general, similar to the current one, a single stage process. We still have provision for direct awards where any kind of contract falls into an exemption, and there are some changes around exemptions, but again, you still have exemptions for certain categories. We actually did a bit of training on that. I think it was like year before last, that kind of covers the old regime and the new regime, which I think you can access through our website. So if you're interested in that, go and have a look. But the new kind of big headline change really is this new competitive flexible procedure that's come in. So we've no longer got our CPNs and competitive dialogue processes. We've now got this almost to some extent carte blanche, but actually not, because obviously when you get into the detail of legislation, there are restrictions around it. But effectively, there's a wide discretion now to set your own procedure. So to think about how you want your process to run, to look at, how many stages do you want? How much negotiation do you want? Do you want shortlists? How do you effectively want to run your procedure as a contracting authority? There's going to be a wider discretion with this complex, flexible element, and we expect people to kind of maybe to start off with start tinkering around the edges, maybe change things that annoy them about the current procedures, or maybe include additional stages where they felt actually if we'd had that original, in previous procedures, it would have been really helpful. But I suspect as time goes on and people get more inventive, there might be quite a lot of different processes that come in there. So that's going to be a real point of interest, and also a real opportunity potentially, I think, for contracting authorities in terms of getting what they want. Because I think everyone, well, a lot of people involved in public procurement will have been involved in process where they just think we just know where we want to get to, but actually all of these hoops we need to go through aren't really suited to what we're trying to do, albeit that they're all there for very good reasons. And then I think the other thing that it's got a real potential to help is for SMEs. You know, so if we can have procedures that are less difficult for SMEs to access, then there's a real potential there as well, I think, to kind of bring more people into the market. That's always, and that has been one of the driving forces behind this. And then just a quick word in relation to frameworks. So we've still got the general frameworks that we're used to. You know, we've got these the closed frameworks that we've always had, and we've got dynamic markets now. So there's another relabeling exercise, but it's, you know, we know what that is. But then we've also got this new open frameworks procedure, which is a scheme of frameworks that provides for the award of successive frameworks, but on substantial terms. So the idea here is that you have a total 8 years framework period, so a longer period, but that you can open it again and can you refresh it, and you're kind of driven to do that through the rules. So you've got to do it at least once in the period of the 3 years following the initial award, and then at least once in each 5-year period following the award, but it's all got to end within 8 years. So the idea is that you can have your framework in place, but it just makes it a little bit more flexible. So that's quite an interesting one that I think might be quite helpful for people. As I said, we've done a very high view and a canter through some of the changes. What we're proposing to do for our kind of training for this big change is to kind of break it down into bite-sized pieces so that we can try and get to the point where we can give people meaningful short sessions, so without overloading people, because, you know, there's a lot of detail in this, but to give people a good idea of what's coming up on the run up to October. What we're planning to do is to do regular seminars that pick off these themes, and not just these themes, but some other ones under the Act. And the next one we're going to do is on transparency. So we're going to be looking in more detail at things that James was talking about, the notice requirements, contract management, KPIs, the advantages, and this push for the transparency in a bit more detail about how we expect that to play out. And then following this webinar, we're also going to send a survey to everyone. So we'd be really interested to know which bits you think you'd be particularly interested in. So we've got a list of things that we'd like to present on that we think everyone would be, be helpful for everyone to know. But we'd also, love your feedback on that to see whether, any particular areas that you think it would be really helpful to get a bit more detail on. I said we were answering questions. We've got half a minute, so I'll just have a quick look. We've got quite a few. Any that we don't get to, we will email you after this so that you do get an answer. But got one about, will EU case law still apply? The answer is most probably. I mean, we're not 100% sure, obviously, but we've got things like I mentioned before that we, instead of equal treatment, and we've now got the compete treat suppliers the same unless it's justified not to do so. That sounds like it's pretty much the same thing. So I would expect the courts to still look to EU case law on equal treatment to say, well, this is what that probably means. So I think there's a lot of these things where we expect it to, but we don't necessarily know. And I'll just squeeze one more in. Could what happened under COVID on PPE contracts happen under the new Act? I think the answer is probably yes. There are some changes around new exemptions for emergencies. So for instance, there's a protection of life exemption now. But again, we did a training last year on direct awards and that kind of contracting. So again, that compared the current regime with the new regime. So again, I believe there's a link to that on our website. So if you're interested in that, you can go back there. And I'm afraid the rest of it, I will have to come back to you, or we will have to come back to you by email. But thank you for joining us. Hopefully that's been helpful. And like I say, we'd be really particularly interested in any thoughts you've got on upcoming seminars and what areas in particular you're interested in, because there's a lot to cover. But thank you everyone, and hopefully see you next time.